laugh when you do.
Oh yeah.
Listen to my
Ah, thank you. I'm not the greatest at this yet. Keith here, hoping everybody's having a good day, enjoying life, living life. Now that I got done with the mime part of it, um, want to thank everybody for joining me tonight. Please hit that like, share, and subscribe button. There's a PayPal link down there for anybody who wants to share some love, and of course, the StreamYard link is there for anybody who wants to join the panel. We got John with us tonight. How you doing tonight, John?
Well, I'm doing good, Keith. I mean, I'm still absorbing the show you did last night, which is really nice to, put all that together. It's amazing how much you can do in one show. But um, one question I do have though is about like the legal name that they're making assign a first and last name, right? So doesn't that like remove one of their, fraudulent, conveyances, if you will, if that we're playing into their system, right? First and last, so we can't get them on that one. But okay,
Well,
I just wanted.
yeah, it goes to the individual's name and number, identify the record. So when they ask you for your name and address, that's a name and a number. It's got several names and numbers. In that, it expresses a trust, and they're wanting you to put yourself in that trust as a trustee in contract. That's all they're doing. The individual's name and number identify the record. So if that's what the name and number identify, then what does the name identify? Well, it depends on the grammar. If it's all uppercase, then it's identifying as a title of a trust. If it's upper and lowercase, it's identifying a legal name in one capacity or another, depending on if it's last name first, first name, last name, firm name. We're finding all these different things out. So the proper grammatical style isn't a legal name of any sort. It's the given name. That's it. I'm Keith. I was given the name Keith. You can call me Keith. Now, I might decide upon our conversation, I might decide I want to change that and just have you call me brother. I might also change that and have you call me boss,
Right,
depending on the situation. So,
right. All right, that clears that up. Thanks. I know they're
yep,
really playing the name game on us. It's amazing.
yep. And so before we get started, um, let me first welcome Russ. How you doing tonight, Russ?
Good, good, good. How's everybody else doing? Hopefully
Good.
well.
Yeah.
Absolutely, absolutely.
How you doing, Russ?
Good, good. Hello in the chat.
And before we get started with tonight's show, I'm in a particular mood, and I may need a place to go because I'm done putting up with shit, even my companion shit and everything. If you're so self-centered that you think I'm doing this just for you, you forget the concept of you give a man a fish, you feed him for a day. I'm not here to give you a fish because it's much easier for me to teach and show by example and reason and logic what this stuff is and how it's supposed to work. And if you think it's all about you and your impatience and your wants and desires that you start making demands on me, you're in the wrong place. This isn't for demand. It isn't for sale. It's freely given because the base principle is the next generation, not you, not me. That's the problem. The self-centeredness. Fuck off if you don't like it. I ain't got time. Shit I don't have time for. This shit, their shit, your shit. Any of this shit. What is it? More shit. Anything that doesn't have shit to do with me. Because it's my message that flows through me from my experiences. And I'm tired of being ripped from my family's arms, having my family ripped from my arms, and seeing it done daily, in and out. It's time to stop it. And they can't do it themselves because they're still children. If you expect them to eat daily, you have to both feed them and teach them so that when they get old enough, they can feed themselves and pass that teaching on. My people are destroyed for lack of knowledge. And if you want to sit in your cognitive dissonance and say, oh, well, that's on you. That's why I say, I love you, but I don't give a rat's ass whether you love me back. Because in the end, we're all God's children. We're all children of God. And that's what we're supposed to love as a whole. So if you want to be self-centered and think I need to direct all my love towards you, then fuck you. So let's get into it. And my apologies if that hurts anybody.
No, Keith, that's nothing.
I feel the same way,
You
bro.
have foundation. You have foundation, Keith. That's all you need. You have our love too.
So let's take a look at this. As the title says, the 3-card Monte the Banks play with your assets. So we're going to listen to this guy. This is from 12 years ago. And he's got an interesting phrase that he throws in there that you guys might remember hearing me say before. And it's that credit default swap. See, when they got him on the mortgage swaps, all they did was change what or where they did that. They still did the swap. They just did it somewhere else. Now, instead of a mortgage swap, it's called a credit default swap. So pay attention. It's a 3-card Monte game, and you're part of it. If you don't know what you're doing, then I suggest you stop and learn. Because if you keep feeding on the poison, that's what you're going to end up with. You're going to poison yourself. And in that poison, you're going to pass that poison on to your children. And they're going to walk into the same fucking bank and do the same goddamn thing.
Our knowledge. Let's share our knowledge. Let's share our talent, because without each other, it's a lonely road.
Well, I couldn't agree more. You know, I remember when I had the pleasure of first coming into contact and making your acquaintance, you and Dr. Klaus a few years ago, and you know, Dr. Klaus, your partner, continued to talk to me about quiet title, and at the time, I was experiencing some issues with my mortgage lender. I was also
And I want you guys to pay attention to what he says about this quiet title thing and why I've been hounding everybody on contracts. That's your remedy. If you're allowed to create your own remedy, that means you're allowed to put your own conditions on things. That means you're allowed to make your own contract, which is the very base principle of a negotiable instrument.
helping clients and picking up property subject to and helping people from the trustee side of it. And no one had a clue what quiet title is. I didn't know what I was doing. A lot of the attorneys didn't know, but I still just followed your advice. And it's just amazing to see where you've gone with this knowledge and the fact that now you're doing trainings and teaching attorneys around the country about this stuff. And it's really relatively new, I guess, even from a legal perspective, or at least with foreclosures. So I don't know if you want to maybe, as we just start off slowly getting into it while a few more people join, I don't know if you want to jump in a little bit and talk about how you got into quiet title.
Right. Here's what we'll do. Okay? Because I welcome this opportunity to chat with everybody, and thank you for taking time out of your evening and giving the old man your ear. Here's really what has transpired. You know, if you look back when you bought a home, you went to the bank and you filled out some paperwork. And one of the pieces of paper that you signed was your mortgage. and it was notarized, and it was recorded with the birth deeds, register of deeds, or clerk of county, clerk of court, whatever. Okay. And the other piece of paper that you filled out and signed was a promise. And let's say you borrowed $400,000. Well, you signed a piece of paper where you promised to pay that man across the table or his representative $400,000 over a period of 30 years or 20 years or whatever the term was. But you signed that piece of paper and it was not notarized. But it was like signing a blank check. But it was a promise to pay, which made it a negotiable instrument. Now, when you...
And I just want to make a point here. If you're still down there, Travis, you know, as we were speaking about over there in Jack's chat, this would be a great opportunity for Jack to come over and join this panel. See, it's not just Paul and Tommy and all those other heathens that want to run their mouths about me. I ain't got time for that shit. I got time for people that have a need to learn this stuff, but even they refuse it. It's pathetic. Go ahead.
Look at the positive in it all. If they're talking about you, they're leaving somebody else alone.
Bitch, if they're talking about me, they're a motherfucking fan.
Exactly.
When you signed that paper, you thought that the bank was going to give you $400,000. That's what you thought. Well, when you signed that piece of paper, what did they give you? They didn't give you anything yet. You just signed the document, and that piece of paper became an asset for that bank. It was now an asset. Asset that they owned. You no longer owned it. Yours was a promise to pay. So that asset was now $400,000 of theirs, and here's what they did with it. They didn't give you any money yet, but they took that asset and they created a bond, just like you would bail your nephew out of jail. They created a bond, and that bond they took it to the federal.
I just want to make a note here, because this is one of those funny aspects, guys. I'm sitting here and I'm watching this counter. You know, most videos, we get going and we get started. I got about 15, 20 viewers. But when I got one up here, Card Monte, the banks play with your assets to try to help people understand the basic concept. And all of a sudden the views are 3. It tells me either the YouTube is shadow banning me somehow, some way, or whatever because of the title, whatever. I don't know. I don't care. Or that people just plain aren't interested in this. But that's okay.
Federal Reserve, and the Federal Reserve gave them approximately 10 times the amount of your promise to pay. Now, let's say your promise to pay was $400,000. The Federal Reserve gave them a credit of about $4 million. Now, how much money have they put up? They have put up absolutely zero. They leveraged, and the technical word for it is monetized, but they leveraged your promise to pay to create $4 million. And they still had your promise to pay. They kept it. They just created a bond. They then took your promise to pay to another party, and we'll call that party a wholesaler. And that wholesaler took it to what we call an aggregator or trustee. And it was then sold to a trust. And 95% of the trusts are in New York. So it was sold on Wall Street. Well, where did the money come from for this note? Where did it come from? Well, the trust filed, before you even applied for that note, the trust filed what we call an 8K filing with the Securities and Exchange Commission.
And they have to do that in order to securitize it. So what they've done is they've taken property from you that doesn't belong to them, and they securitized it, and then they're going to take it to a discount window as if though it's theirs, and take out a loan of 10 times the amount. Listen to him.
And we'll call it the Rosado Trust. And they told the Securities and Exchange Commission that they were going to sell investment certificates, and they were what we call mortgage-backed securities, or they were called CDOs, collateralized debt obligations, whatever fancy term they called it. That note was the security for these folks to induce certificate holders or investors. Let's just say the folks that are listening to this phone call, let's say they represent the school teachers in their area. So the school teachers pension plan invested $10 million each into this trust that was backed by your promise to pay. So they were given, let's say 6% return on their investment. But you were paying maybe 7%. So the trust was earning money, okay? Now, those certificates, okay, that were purchased by the investors, okay, that money went back to the bank that you signed that promise to pay with, and that's where the funds came from for you to buy your house.
Huh? Huh? You mean they got the funds from me?
Yep. Yep.
No way.
There's no way. You have to go to work, guys. You have to get a job.
And they don't issue a transaction report, 1099, which is supposed to be given to the creditor, which is us.
Yep. See, and watch what he says about getting into those records and doing the forensics and stuff. This guy's great. And like I said, it's 12 years ago. And then I got a couple more lined up. One from, let me see here. Dang it. 9 years ago. And another one from, I think, 8 or 9 years ago. 8 years ago. Yeah, so I've got one from, this one's 12 years ago. I got another one from 9 years ago, another one from 8 years ago. I haven't watched these other two yet. We're just doing this one for tonight.
Wow. Wow. Listen to this for a minute. That piece of paper that was never notarized traveled all around the world, gathering a lot of money. It created $4 million for the bank in credit on your signature. It also induced a lot of school teachers' pension plans or firefighters' pension plans to invest into that trust. They got an investment certificate, and the funds came backwards to the bank, and the bank then, through the title company, they provided the $400,000 to purchase the house.
And I want to remind everybody, it's the fire stations that are like a foundling hospital. You can take your children, if you abandon them, to a firehouse. Not a word said. It is the public education system that is the classification system that determines what people will do when they're growing up. That doesn't sound like free choice to me. That sounds like somebody, and like I said, the hospitals are known as foundling hospitals. You're literally born under a spell of illness. Inpatient hospital treatment beginning the first day. That's the first day you were born. Your mom goes in the first day she gets inpatient hospital treatment under a spell of illness when she's giving birth or bearing labor of a legacy heir. And nobody ever records that part. And that's the problem. All the grammar and the language. You better start learning.
Good deal. Very good deal. For who? For the bank. They got $4 million in credit and didn't put up a name.
$4 million in credit. Understand the language. They didn't get $4 million in dollars in money. They got $4 million in credit.
Nickel. Now, the trustee for this trust, he is provided what we call a pooling and services agreement. That's his management book. That's his rules. That's what he has to follow to comply with the SEC rules.
That's the pooling and servicing agreement that goes on down at the local courthouse for the court registry investment system. So when they invest in that $350 bond and they put it to the window, guess what? They're taking $3,500 10 times at minimum.
So in that pooling and services agreement, there's a clause in there that says if you fail to pay your mortgage, they entered into an insurance contract so that if that mortgage wasn't paid, the insurance company would pay it. But the money wouldn't go to you. It would go to the trust. So then we call that a credit default swap.
Credit default swap. They went from a mortgage swap to a credit default swap.
The insurance company is, listen to this, A.I.G. Now, when you got in trouble and, you lost your job or your overtime or for whatever reason, you tried to contact the bank and you got the runaround. You ended up talking to this person, that person, submit these papers. Oh, we lost them, submit them again.
And AIG is American International Group, and that's like a insurance underwriting corporation. And I believe I have to do some follow-up in current research to make sure, but I believe they work with Lloyd's of London, the assayers.
All that crap that goes with it. But you were told we can't help you until you're 90 days late. Everybody's heard that. Well, guess what happened on day 91? On day 91, the insurance policy that the trustee entered into with AIG triggered a payoff, and the trust received the full amount of the note, regardless of how much you've paid on your mortgage. They got the full amount of the note. So if the note...
So they've already been paid, folks. The payment's already been made.
Was insured for $400,000. The trust got $400,000.
And the Department of
But here's
Agriculture
the
backed
mystery
it up.
here.
Yeah. Yep. Everything is, all the credit system is backed up by the agriculture. Federal Farm Agricultural Credit Act.
And I'll explain it as easy as I can. the Federal Reserve allowed the trust to leverage that $400,000 note 30 times. So they created
So now it's 30 times. That's 12 million.
30 different levels.
There must be sub-trustees, Keith, because I thought the Fed was like trustee over the Treasury, as is.
Yeah, these are all trust trustees, not the Federal Reserve System.
Okay.
That's not a trust.
So third party.
Right.
Now your $400,000
Third party investors.
note.
Now, they would still have that fiduciary obligation, though, right? Dealing in finances.
Not as investors.
That's a problem because they're third party.
Well, yeah, but that's why they're third party. They're
Who's
not
gonna do-
subject.
These people should hang.
Yeah, they're not subject to the contract though.
Right.
That's that
But-
plausible deniability. Hey, I didn't know anything about those internal contracts. I was a third party investor.
Yeah, but what about that obligation as a man?
Yeah, you're still investing in what you have been presented as being honorable, and you stood in honor. You know, you didn't partake of any deceit. You thought it was a clean deal.
How do you see? That's the hard. That's where I got a problem.
Well,
How
yeah,
do you know.
listen to how this guy explains it, and you'll see how they have that plausible deniability the way the law is written. This is why I tell you, if you don't know how banking is done, you shouldn't be doing it.
Yeah.
Purchased by.
There's no gold clause in the mortgage, right? That's why they went to 30-year futures.
Right. It's not.
Right.
You have to have a limitation on the dollar for dollar. Well, define the dollar.
Yeah.
You can't. It's a conversion of anything you have that's material or immaterial, the tangible and intangible. Like I said, I can take a blank piece of paper, and I've even got my stationery with my sigil on it and everything. It's already got that value on it, and it's commercial paper. Well, that sounds like negotiable instruments to me. I can start writing on it and write out my negotiation. That's where I put my value as it relates to a dollar. How can I do that? Credit.
Other lenders, and along we go. So let's go back to the default. The AIG paid off the note when it was 91 days late. So at this point, who has lost any money? Nobody except AIG or insurers like that. Smith, Solomon, Barney Brothers, and all that stuff.
And yourself, the one that's been paying for it out of pocket when you shouldn't have. Let's not forget that.
Now, someone attempts to foreclose. And let's say the lender that you got the note from, they're going to foreclose on you. Or the trust is going to foreclose on you. Or let's say it's Wells Fargo acting as trustee for Bear Stearns Trust. Well, they're trying to steal the house because nobody has any skin in the game. They've all been paid commissions.
Except, again, you and AIG.
And they've been very successful in stealing houses. What happened here? Well, I sat in the Fort Myers courtroom many times, and I watched average folks, lose their house in 5 minutes because they didn't have an idea of what to do, didn't know where to go for an answer, and didn't have any money. Now,
you've already seen this one?
Quite a while back, I believe. Is this where these judges are sitting there and that's all they do is these? And they're retirees and everything else?
No, this is, I don't think so. He goes on about how, and explains how this whole mortgage fraud happens. It's just him and this other guy.
In this foreclosure arena, So I'll call it a football field. In this field of litigation, the only players are the consumers who have enough money to pay an attorney. And what is he doing? He's delaying the time so that you maybe save a couple of months of rent or mortgage payments. But at the end of the day, when you pull the shade down, turn the lights out, he wins a dismissal without prejudice, which means the bank that is foreclosing, who doesn't have any skin in the game, will come back again in a month and try to foreclose again. So what is quiet title? Here's what I did.
Pay attention, folks. What is quiet title? And he's going to talk about a special warranty deed. And there's specifics about a special warranty deed. It's relative to the previous buyer or the previous owner. And if the bank is the previous owner and you have a special warranty deed that only goes back to him or the bank, the previous owner, then there's likelihood, and this guy says 95%, and I tend to agree with it, likelihood that it's not a clean title. Because there's a limitation. That special warranty deed is a limitation saying that there may not be clean title prior to the previous owner. So they're limiting the title just to the previous owner. So there's a great possibility that may not be a clean title. So you're going to quiet it. Check it. Oops, guess what?
I said, okay, when you're in trouble, you're trying to find some person to talk to, someone to give you straight answers. And what do? They stonewall you. They firewall you. You can't talk to this person, that person, and all that crap. So a quiet title action, which has nothing to do with your debt, nothing to do with your debt. A quiet title action means this. Your Honor, I cannot sell my house because the chain of title has been broken. And why?
I cannot sell the title to my house because the chain of title has been broken. How do we know this? The special warranty deed and that limitation saying clearly in legal that it is not guaranteeing the title beyond the previous owner. So it may not be clean. Guess what?
Why was it broken? It was broken when you closed on the mortgage and MERS was involved. MERS took possession of the of the mortgage electronically, and the bank sold the note.
So it separated what was supposed to be together. This is why when they bring that promissory note into the court, guess what? It's supposed to be with the mortgage. You don't care if it's a copy or not. That's evidence that it's not true, of course. You want the original that is still attached to the mortgage. One basic element of law that's not there, and guess what? That title's not clean. So when you get a special warranty deed saying that there's somewhere along the line there wasn't that attachment, guess what? That proves as a broken chain of title, and you can't go back and find out who the real owner is. All you can do is advertise, I'm taking possession by right. Anybody has any adverse claim, please come forth.
Now,
you see, we're not supposed to be buying and selling this property, these lands that we think we are. See, the bank has got a title and a mortgage and a promissory note, and those are all supposed to be connected somewhere, somehow, to show true ownership, and they all get separated. So what in fact is happening is you're only buying possession of a house, the actual things that are on the land, because you can't buy the land. And in that, it's all being separated, so you really don't have any true ownership anywhere except the one that is in possession of the thing, because the title itself is no good.
So they
How
never
we doing
transfer
so
title
far?
to the lender then, and they sell derivatives instead, right?
Correct. And that's called shredding. It's the same thing they do at the county courthouse in the court registry investment system. They get that $350 bond, and what they do is they call it shredding. But what they're going to do is they're going to slice it up into 10 parts and sell each part for $350. Right?
Right.
Or
Yeah.
it's 30 parts, you know?
Randy?
Fantastic, Reach.
Huh?
I think fantastic.
Okay, all right. I'll keep
Actually,
going.
what I'll do is, what I'll do is I'll give a couple of pieces of information because I know some people may have some questions.
Okay.
So what you can do is if you've got questions and you have the ability to text or email, you can text the questions into 561-444-9179, 561-444-9179, or you can email them to Quiet Title. It's quiet-title@rosadocompanies.com. That's plural, R-O-S-A-D-O companies, plural.com, and I'll get them out to Regis for you. In the meantime, Regis, go ahead.
Okay, I'm glad you took that little break because I took a little sip of my Merlot wine. All right.
Anytime you feel the need, let me know.
All right, I'm ready to go. Right. Well, the more, when you closed on the loan and MERS was involved, the mortgage became separated from the note. And you can't, once the mortgage and the note are separated, the chain of title is broken. The chain of title.
And can you spend a minute talking, because right now, you know, anyone that's in the industry sees what's going on with MERS and everything's coming down, but I know there's a lot of people that doesn't understand the significance. Can you spend just a moment talking about MERS and why that's such an important role for Quiet Title?
Right. MERS technically is Mortgage Electronic Registration Systems. They were formed by the banks, and the banks became members. And MERS, at the closing table, is named as the nominee lender. They take possession of the mortgage electronically, not the hard copy, but electronically. MERS, their theory is and was that by they being the nominee lender and having possession of the mortgage electronically, they believe that the note followed the mortgage. And there are some judges who don't understand this who agreed with that. However, the U.S. Supreme Court in 1872 said, if the note and the mortgage are separated because one secures the other, if they're separated, they're both null and void. And to simplify it, if you were going to buy my car, you're not going to give...
Because one secures the other. This is the securitization.
me the check until I give you the title. The keys to the car are one thing, but the title is another thing. Now, MERS took possession of the mortgage, but they could not take possession of the note because the Kansas Supreme Court ruled that they are not a lender. With that being said, your loan was bifurcated. That's a legal word. Bifurcated right at the closing, but you didn't know that. Now, that means your chain of title was broken. So fast forwarding ahead, we simply said, and this workbook that I created, and I'm the only layman that I know of, and I've been told this, that's ever been approved by the Florida Bar to teach attorneys about this subject. I've subsequently been approved by the Georgia Bar, the Wisconsin Bar, the Nevada Bar, and other states to follow. So that's quite an accomplishment for a little white-haired old man to be able to be certified to teach attorneys. So now, when we have the basis for a quiet title action, we simply say to the court, Your Honor, the chain of title is broken. I cannot sell my house.
Your Honor, the chain of title to the estate being administered in these procedures is broken. I cannot defend such a suit.
I'll give you an example of how important the chain of title is. I bought a home that Dr. Klaus, my business partner, found for me. And at the closing table, the closing clerk...
At least not in these courts of law. However, afforded a court of equity, I assure you, I can settle these matters.
Girl I knew, she'd been closing for 33 years. I said to her, Audrey, I just signed a very, very important document. that's worth a lot of money. I need a receipt for my signature. When you do a transaction with a credit card.
Okay. I need a receipt for my signature when you use a credit card, like you started to say. And this is what I've mentioned. Check that receipt you get. If you are required to give a signature in your name, and that credit card is in your name, and you give that card, put that card in that machine, and it gives you a receipt back, and it says U.S. debit. Whose name is that in? Would that be the spoliated owner? So you hand it back, you surrender it to the spoliated owner, so he can obtain indemnification.
Don't you get a receipt? Absolutely. When you spend money, don't you get a receipt? Absolutely. I was just spending a lot of money and I asked for a receipt. And she said, we can't do that. What they gave me for a receipt was a special warranty deed. That means the bank who said they owned the home was guaranteeing me a clean title only from the time that they owned the home until the time I bought it.
So they're saying they couldn't guarantee a clean title before them. Understand, reading between the lines there, folks. They're saying that impropriety may be at hand in the very purchase by the bank because they didn't validate whether the title was clean prior to that. Saying that they are willing to make underhanded dealings, pretty much saying they're willing to steal houses from people.
Well, here in Cape Coral, we recently had, well, not recently, back in July, a headline story where an attorney and a real estate broker paid a bank $158,000 cash, and the bank did not own the home. And the attorney accepted a special warranty deed. Well, today, if you're buying an REO or a foreclosure home, I can solid guarantee you, you cannot get title insurance. So with that,
welcome, Hadassah. How you doing tonight?
I'm good. How are you?
Good. Good to see you again.
You too.
Got anything on this so far?
Well, that's the whole point for the warranty deed, isn't it? Because the warranty is insurance, except for it's not, because it's the bond. That's what I found with they can't hold most of these entities, companies, counties, all that. It's actually the county I find that is holding the note, the original, and they keep selling it over and over again.
Yep. And that warranty deed.
Mm-hmm.
I did a video on the term warrant itself as it relates to indemnification. Is that warrant means that the information in the instrument is warranted, meaning that it's true and correct. It's been assured. And those are all relative terms to a grant. And that's what you do when you put down these terms and conditions on these documents is you grant them. You're saying they're true and correct. I assure you, yeah, I'm a resident. Yeah, I'm a United States citizen. Come to find out, much of it is not true.
Well, in the assurance versus insurance, big difference, right?
Yep, absolutely. As well as
that's like one thing is, yeah.
Right,
they
as well
get paid by warrant.
Yeah. As well as insure. Everything comes in a trinity, folks. Assure, insure, and ensure.
It's like admission, omission, permission.
Yep.
All having to do with the mission.
The quiet title action flushes out anybody who has a recorded legal interest in the title, not the note. The note has nothing to do with the quiet title action.
So it'll flush out anybody that's got a legal interest. Does the bank have a legal interest? If they can't show where that legal interest came from first by showing clean title themselves, then they can't have legal interest. It shows that something just appeared out of thin air. It's like saying, you know, that house that was across the street when I was a kid, 45 years ago. I remember the owner over there. All of a sudden, the house is gone. She's still there.
Do you know how they create the interest? I just found this out recently. It's evil genius, but it's quite brilliant actually. Because we always think that they're robbing from the cookie jar, where in actuality they're just putting a cookie in our jar so they have an interest, right?
Mm-hmm.
How they fund these, literally, like a mortgage, for instance, is funded with a $10 money order or stamp.
Mm-hmm.
That they then, because it's the 2 cents for every $100, right? You have to pay the stamp tax.
Capital transfer tax stamp.
Yep. But the land value, which for that $10 stamp would be $200,000, right? They use the EFTPS system, and they only transfer $180,000. They leave that $20,000 off, and then they go ahead and turn around and make a $10 million bond from that transaction. So the fact that they're saying that we didn't pay that $20,000, that's what creates their interest. It's literally 1%, which is just an owner. It's not because the ultimate beneficial owner has to be 10% or more. An ultimate beneficial owner is 25% or more.
Yeah, we're the ultimate owners. Anyway.
Mm-hmm. Go ahead.
And in a lot of cases, no one shows up. We have one here in Cape Coral. Fannie Mae didn't show up because they didn't have a recorded interest. The mortgage and the note were never assigned to them. Now, with that being said, I know it's...
So the bank may hold certain property, but it's never been assigned to them. That's the thing that warranty deed is telling you. It just magically appeared in their holdings. It was never assigned to them.
Sounds convoluted, but what's the meat and potatoes of tonight's call? The meat and potatoes of tonight's call is, in order to file a quiet title action, you cannot go into court with hearsay evidence. You cannot say to the judge, Your Honor, I found this out, or my friend told me this, or I think this. You get laughed at and thrown out, okay? What you need is a securitization audit, which follows the paper trail from the time you closed until it enters into the trust, and a Bloomberg financial report that pulls out all of the financial information about the trust. When you have that information, and it's accompanied with an affidavit sworn under the penalty of perjury, you now have evidence, you now have admissible evidence to the court that the note was paid off when the insurance or credit default file was triggered.
To the trust, even, to have it paid off. I don't even know if they have that. Or authority to use the cap's name. I mean,
note was paid off. Who is damaged? Who is damaged? Nobody. The only logical people with a claim to that house, only logical people, would be the insurance company that paid out the claim. But now here's the end of my story tonight, and then I'll open it up for questions. If you have your vehicle insured by, let's say, Geico, and you total it, Geico will write you a check for the value of the vehicle, but who owns the salvage rights? Now think about that for a minute, right? your question down. Think about it. The salvage rights are owned by Geico. They then part it out or salvage, sell it, whatever, so they can minimize their losses. Well, in the foreclosure arena, the insurance company is Geico, and if they paid off the certificate holders, then they would have a claim to the house. Logical. Except they insured unsecured notes.
There's no rescission documents given, no 1098 form issued. I got a long list on mortgages.
Yeah, my apologies. That's that thing about that credit default swap and everything. See, you're the one insuring it. It's a big insurance scheme. And when you go around insuring things, guess what? You're insuring something that's not secured. And then you secure it, and guess what? They turn around and you hand it back to them, and they turn around and sell it. That's a debt note. It's the creation of a debt by the signature and the premises that are laying in it, and the thing that you don't know about the language and not knowing how to sign it appropriately to present your capacity so that you're not held liable. It's a salvage system, but it's all about salvation.
Remember?
That's why
At the closing
redemption
table?
certificates are so important, right?
The what?
Redemption certificates.
Yep, and that's what we're talking about. Indemnification is the same thing as redemption. I'll pull something up here and see if we can take a look at it when we're done, but it's interesting how these words play together.
MERS became the nominee lender. It separated the note from the mortgage. The U.S. Supreme Court says that they're separated. They're both null and void. Well, Geico insured unsecured notes because the notes that were not accompanied by the mortgage or vice versa. Therefore, they had no claim on the wreck or the house. Whew. Now.
So essentially they're double dipping or more. They're double dipping and triple dipping even.
Absolutely.
See, you're actually the one that's got the claim on the property. That's why I say when it comes to that salvation, you're the one that's actually got the claim on the property as the intended benefactor, beneficiary, however you want to put that. And then in that, you have the ability to settle the matters. That's the salvation process. That's the redemption. And that's done through a surrender back to the other party that has interest in it that actually created that vessel for you without knowing that you never intended nor learned how to operate the damn thing. That's that resurrection.
And sponsors. Patron and sponsor, another two titles that, as far as benefactor goes, it's they're a lot better than beneficiary because
Yes, patron and sponsor. Sponsor is a nice one when it comes to the commercial side, and that's the one that's funding everything. Patron is the one that comes from the spiritual side, and that's our Father which art in heaven. All credit goes to him.
Well, and it also comes to performing rights societies and, creativity. You have patron of the arts, right?
Yep. Yeah, it's your talents in the creativity.
Geico
that
has
word
a
talent is
big-time lawsuit against Bank of America because Geico, I'm not Geico, my God. When you get my age, you can invent words. AIG has a major lawsuit against Bank of America because Bank of America defrauded them on the quality of the loans. The loans were rated AAA by Standard & Poor's or Moody's or whatever, when in fact...
And obviously, I think this would be a good tactic to use against that credit score industry and all that shit. They used it against you. They converted things and used it against you. See, the informed
because
use...
it's not actually your credit score.
Correct. Informed use of credit will tell you how everything works, and that you should understand that if there's a credit score, then why is it there no debit score? score? Why is there no debt score? You know, what the, shouldn't you have something to
Yeah, I know,
compare
right?
it with?
They slid
Mhm.
into that pile of
Yeah.
loans. They slid in some toxic loans, some marginal loans, and Geico ended up paying based on misrepresentation. Wow, what a hornet's nest. So, for those folks who are interested in taking a step further and learning more, I would suggest this. Randy, I think you've got an event, a workshop, or something scheduled there in West Palm Beach. Anybody who is an investor, even a homeowner who has concerns, or an attorney, I would highly recommend that they attend your event. In fact, I think I'm scheduled to speak at it. I would highly recommend. Yeah, I would highly recommend that they attend it because there's so much information to learn. Now, I want to add this. Today, I had a call from the CEO of a legal group that represents, or these attorneys are members from all over the country. And they want me to make a commitment to teach this legal group all about quiet title because, and here is the nuts and bolts of it. Everybody that has an attorney, they take all of their problems to the attorney, where in the medical field, you don't take a heart problem to a kidney specialist. You don't take a back pain to a foot doctor. But in the legal arena, people assume that their attorney knows everything. My son is an attorney, and he's dumber than a box of rocks. He only knows one thing: divorces. So when I mentioned quiet titles to Timmy, he said, "Dad, we didn't have that in college. I have to go find out about it." So that's the reason that we're teaching attorneys, so that folks that
See, like I've said before, they're not teaching attorneys this stuff in those colleges. Never have, never will.
They
You
teach
start learning.
procedure, not law.
Yeah, you start educating people how to correct their records, and it doesn't come down to a matter of anything but, hey, equity doesn't allow a statute to be used as a cloak for fraud, and that statute is in error, not me.
have an issue or
Well,
they
and
want
it's
the
when you
answers, we can
start
direct
looking
them.
at the statutes. Sorry.
No, that's
Most of them
fine.
contradict each other or themselves.
Yeah,
All the
that's
statutes.
that's
Yeah.
what I say. That's why I say use them against them. That's inconsistent. What is a person?
Mhm.
What is a resident? Resident Iowa determination for resident is for income tax purposes. I'm sorry, I haven't had a job or worked for any employer for 8 years.
Well, but how they're putting it as far as like when it applies to the mortgages and land or ownership, all that, is they're putting you as a resident for that medical facility that they've put that property under. So
Yeah,
that's why you don't get paid and you're considered a constituent. But you
yeah,
can use that to your advantage because if you're a student,
the maritime contractor that is incompetent to contract himself, so he does it by votes in elections.
well, but how they're putting us with the whole resident thing, it's literally like a resident in a hospital. You're a student, you have to put in your residency, you're basically
Yeah.
your volunteer time before you
Company
become a
A,
doctor.
Company B,
But because
yeah,
exactly.
Company
But when
A,
you're a
Company
student,
B, Company
right?
C, military.
Mm-hmm. But when
Everything.
you're a student, you're indemnified
Yep.
from mistakes, aren't you?
Funny how that works, huh?
Yeah, that's why they're always
understands
practicing,
it.
right?
And once an attorney understands it, it's much easier to have the operation done. And you certainly don't want a heart surgeon operating on a blister on your foot. It's a waste of money. So we've identified this. We now have a group of attorneys started. And today I talked to the CEO of a legal group that has attorneys in every state except Hawaii, Alaska, and the Cowboy states. And they have, I think, 62 law firms. And they want me to teach all of those law firms all about quiet title because these boys, they've admitted it. They simply don't know it, but they won't tell it.
They simply don't know it. That's what I keep telling people. Many of these people don't even understand what we're researching and learning because they don't know it. They haven't researched it and learned it.
Exactly. I know. I was talking with a friend of mine the other day about putting together a school for professionals that are already in the industry just to teach them their industry because, like you said, they're not getting taught most of this stuff, especially when it comes to things like, legal law, taxes, business.
Yeah, my dad was My dad was a real estate appraiser for the government all of his life. I guarantee he didn't know the first thing about tax law or anything about business law. My mom.
Oh, my mom was a broker. Yeah.
My mom was a Social Security, worked at Social Security for 29 years. I guarantee you she never read the Social Security Act.
I
ever have an attorney tell you?
I can almost guarantee that. I spoke to someone that I met that was actually a prosecutor for the IRS before I got disbarred. I talked to him for a couple of hours, and everything that I was talking to him about, and this was a couple of years ago. I've learned a lot since then, but he didn't have any clue about what I was saying. He never even encountered it. And he was a prosecutor. I'm like, this is a problem.
Yeah,
right?
I had the local assistant DA tell me here not too long ago that they don't abide by the federal code.
I don't know something. He said, "Well, let me think about that a little bit, and I'll call the colleague in, and we'll get it done." They never admit defeat. Hell, attorneys, if you ask them their scorecard, they'll say, "Well, I had 500 cases and I won 400 of them. Where are the other 400 losers?" All right, I shot my wad. I'm going to take another sip of Merlot here.
All right, well, I'll jump in and make some announcements, Reed. That was awesome. And for everyone out there, just a few announcements. We have a full workshop. It's going to be a full day, 8 a.m. to 6 p.m. on December 10th. And I know December is a tough time, but it's beautiful here in Florida. It's going to be at the Crown Plaza in West Palm Beach. It's an all-day event. Breakfast, lunch is covered, beverages throughout the day, and just a ton of information from Regis and his colleagues at the U.S. Property Shop. And then I want to announce another date that just came up today in Greensboro, North Carolina. My old friend from 20 plus years ago, my childhood friend who got me my first sales job, Phil Dean, is out there leading the workshop in Greensboro in January. So if December doesn't work for you, we've got January 21st at the Comfort Suite. If you need information on that event, you can contact Phil directly. Phil Dean's number is 336-882-6666. And for details on the event in West Palm Beach, you can contact me, Randy Rosado. It's 561-444-9179. And Rita, just some last thoughts. Tell people what exactly they'll take out of this event after they spend all day there. And for the attorneys, I believe it's 7 continuing education credits for the one day.
Yeah, it's seven CLE hours.
Notice what they said there too. You were talking about the students being indemnified, and what do they give students? Credits. You had to have how many credits?
And they have constant continuing. Yeah, they have there's requirements for them to always have continuing education hours, right?
Yeah, you get credits for graduating high school, or you get credits no matter what, whether you graduate or not. That's what you're doing, is earning credits. It's a credit system.
Well, and if you're practicing,
which goes to the merits, and understand again, merits etymologically means spiritual credits.
And that's all government employees are actually based on the merit system for all of their pay.
Yeah, merits and demerits.
Also, Randy, listen, for those folks who are on the call tonight, whether they enroll in the workshop or not, I've got a gift for them just for their interest. Okay, if they take 5 minutes and give you their email address, and you forward that to me, I will give them a free copy of a book that we have on the internet called Getting Out of Credit Prison. It's got tremendous reviews. It's a wonderful book.
Getting Out of Credit Prison. Let me look that up.
Well, because probably roughly about 85 to 90% of all of our financial transactions are run through the Bureau of Prisons.
Okay, let's see here. On Amazon, it's got Get Out of Credit Prison. Get Out of Credit Prison was written to assist those consumers that are facing credit issues or have suffered from credit issues. And so when it says Get Out of Credit Prison, that's right in line. Well, if there's credit score, where's the debt score? Where's the thing that balances it? Otherwise, you would be locked into a credit score. They don't want to talk
about the debit.
Exactly.
They can't hold the debit. Because they can't hold them, so they don't want to talk about them.
Well, look at the name on the receipt. Now, if they're supposed to bring the suit in the name of the real party in interest, and that receipt says U.S. debit, shouldn't they be bringing it in the name of the United States?
Technically, yes. Just like it's funny because if you look at like a court case for the county, in particular, or a municipality. If you look at it, it's funny because they put the county or municipality in one box, right? And then they put, the people of the state of whatever. And then they put a little V, by the way. And that doesn't always mean versus, by the way. It can mean a lot of things. And then they put, a name. A lot of times they don't even put a description of that or what title that individual's, acting in. I found out actually that's because they're literally using our name as an address. It's a shipping label. Yeah, right? It's funny.
It's the legal representation. It's the legal representation.
Yeah, because we're the people, right? Yeah. So the funny part is we're the people. So then whenever you're in court, you always have the DA or whoever stand up, and the judge will, say, because you have to do a notice of appearance, which, by the way, is so incredibly important, guys. I cannot even stress that more. And I can't stress it enough. Notice of appearance. You have to appear. The heir has to appear.
If you're going to go into a court of law, otherwise that same concept, instead of a notice of appearance, it's a gentleman always announces his presence. That's the equitable side. The language is different, folks. You have to understand, you've been indoctrinated so deeply.
Well, and when you're dealing with the equitable side, you would say notice of appearance for the heir, because the heir must appear. If you're, for the legal side. Right. For the equitable side, you would be present because that estate or endowment from your mother and father was a gift that you have to say thank you for. Yes. Yep. But it's funny how whenever they stand up, the DA will stand up and they'll say, "Here for the people." They never say what people do they?
Yeah, to whom all these gifts present.
Right.
I'll give them as.
So have you ever? I'm curious. Have you ever heard the DA specify, like, "Here for the people"? Because they always stand up, and I always hear them saying, "Here for the people," but they never specify what people.
Yeah, the Commonwealth. That's what they're talking about. It's Commonwealth. That's the only.
Does anybody ever call them on that?
Oh yeah. Yeah,
okay. I'm just curious.
There's a site called freedomfromgovernment.org. You can go check that out. Okay. It's the new site from Lawful Living. Lawful Living has been shut down and moved to Freedom from Government, and it's still run by Malika. She bought Freedom from Government and just decided to incorporate it all into one site. And seems they have a pretty good setup. So it's changing, but incorporating all of Malika's stuff. And there's some success stories in there, folks. You should go check them out.
Well, I know if you call them, if you do a business search for the people of the state of whatever, whatever state you're in, and your department or your Secretary of State, to see if it's a registered business, and it's not. And sometimes it is. Like here, some people have actually claimed it. Yeah.
Yeah, that's one of my main arguments now. Is I was never actually permitted to do business in the state of Iowa, because, as my understanding, I have to take an oath of office as a matter of residency, where no person shall reside within the zone except federal, state, or municipal officers or agents whose resident presence is deemed necessary by the board, meaning I have to have some kind of contract in this public service, which is public trust. I don't see it. It's not there.
And you have to be warranted in order to do so, right?
Yep. Royal Warrant Holders Association.
Oh, we'll get this. Equity?
You do have a question.
I actually found that on the Actors Guild. It's a Actors Equity Association.
Yep.
Which is called the DBA's Equity.
That's why I've got the number of channels I've got on YouTube. I'm constructing it as my own Authors Guild.
Oh, are you? It's like syndicating, right?
Yep. Each one has each one has its own little topical area.
Came in.
Because you have to be diversified.
This question, I'm not going to state the person's name.
Yep.
I'm not sure. But I'm a realtor and investor. I have many properties in various stages of foreclosure, modification, and short sale. Can quiet title action be started at any time during these stages? Are there attorneys in Palm Beaches who can help with this? Who are they? Now, I could kind of answer in terms of the attorneys. I mean, I don't know anybody, but I do have.
Quiet title can be entered at any stage and by anybody.
And an intra-family transfer can be done at any stage and by anybody, and does not have to actually be recorded or on the record.
Correct. That's that living will where the execution of the testator's estate is managed appropriately in private, not in probate, because the living will is recognized.
Yes,
People from the
and you
workshop, so
don't
you
want
can
to go to
contact
probate
me.
because there's settlement company. Settlement
Yeah.
corporations, that's what the probate and all the courts are. They can take 49% to begin with and 98 to 99% in totality, legally and lawfully.
Yeah.
Sadly.
Amazing.
This individual can contact me and I'll get right into that. We'll reply with some information. But we just explain what to do for people like this, where they're in different stages of the foreclosure. I know I've been there, so I can speak from personal experience, but obviously you've explained tonight why modifications aren't happening and short sales aren't happening by the bank. So
Here's the best analogy. The foreclosure defense is like treading water.
Pay attention, folks. Notice he just said treading water. That's kind of like walking on water, right? When you're treading water, it's not quite swimming. It's more like walking. Yeah, it's walking on water. Understand how you walk on water is by knowing how the contracts are, so you can negotiate them.
You need an attorney, or if you feel competent yourself, pro se, to tread water. That's delay, object, delay, production of documents, whatever it takes to extend the action in a foreclosure lawsuit. Okay, so that you do not have a sale. Now, I'm not saying if there has already been a sale of a foreclosed property, that can also be attacked. But it's much easier if you can delay that game. That's the game of litigation. In the meantime, you get your audits, and this is where Dr. Klaus comes in. Here's what you do, and I did this with Regions Bank.
This is the part you need to pay attention to. An audit is basically a contract, so pay attention.
I walked into the bank and I said,
it's also called an abatement, by the way.
Yes. I've done that on the face of envelopes by myself. I audited it myself. If you don't know what an audit is, it's a correction. And if you remember English class, when the teacher took an essay from you and corrected it, she did an audit on it. She found the error.
Red pen.
The bank has dirty diapers and they really smell. Well, he's in conference. I said, that's no problem. I'll just drop the diapers right here. In less than 30 seconds, he comes out of his office and he said, I overheard the conversation. What's the problem? I said, you got dirty diapers. There's fraud in these loans. Now, what do you want to do? Do you want to litigate or you want to negotiate? And so he called his legal department and I said, here's the proof.
Litigate or negotiate. Okay, one is an argument. One is a negotiation to come to terms of agreement.
Meeting of the minds.
Yep.
Compromise.
You people have already been paid. What do you want to do?
Compromise is actually compromise. It's with promise.
And it stopped all the activity in court because
and everyone gets a prize, right?
And that's the value of the securitization audit in the Bloomberg Financial Report. So if I were a real estate
everybody gets a ribbon. We're all cupcakes.
Investor.
Well, everything's a lottery, right?
On any modification because you're dealing with someone who doesn't own the note. Remember earlier in the conversation, a lawyer here in Cape Coral and a real estate broker, they were partners. They paid the bank $156,000. And Randy, I think you saw the article. And the bank didn't own it. So if I'm an investor, how the hell?
And the one that originally drew it up and made it up and signed it doesn't own it either because it was sold. So who owns it?
Do I know who owns it?
Well, and that's the other thing. I've been having people vet these people that they've been dealing with it. Like as far as like the actual real estate agent or the bank or the finance officer that they dealt with originally, all that kind of stuff. What we're finding is it's not even actually the bank. It's these individuals that are going back and they're saying that they're representing something or someone or something, and they're acting in that name, right? And most of the time, they're not even employed by that company.
Yeah.
And when you tell the company
Who
that
owns
you
the
have somebody out here that's like pretending to be employed by them, there's this huge liability. They are going and cleaning house themselves. It's quite
Yeah,
effective.
and those are the ones that are playing the real con game. They're the ones that are playing that credit default swap on the backside there. They're the ones that love it. They'll do a 90-day credit default swap, get paid 90 days, and then turn around and sell 30 of them again.
note?
Yeah, that's a
So the
clearinghouse
only way I
corporation.
can
Yep.
find out who owns the note so I can sit across the table and cut a deal is to flush them out of the woodwork. And how do you flush them out? You sue them. Wow. This old man's got a lot of enthusiasm. I can tell you
Well,
that.
that's what I was going to jump in, Regis, because from a personal
Because they can't bring forth the note. They're making claim to the title, but they can't bring forth the note. Oops. Bifurcation.
experience, I'll say.
And if you don't
in the
bring
case
forward
that it
your
was-
expenses, then you're operating under their tax jurisdiction and not your own. You have to bring forth your expenses.
Yep.
the Fort Myers courtroom, and I got a late start on that. It was probably approaching final judgment before I came in with the interrogatories and some of the defense from Dr. Klaus. And I was able to get the dismissal without prejudice. So my advice in this situation is, when you're defending a foreclosure, when you're doing the short sale, and that part of it, what happens is you're acting as a defendant. So once that case dismisses, you need to move ahead and file again. Would that be on target, Regis? At least that's how I've understood it. And put yourself in the plaintiff position.
And you become the plaintiff.
Exactly. Now we have another question that also came in, and this is
yeah, you become the plaintiff, and that's a counterclaim. And your counterclaim is against the title not being with the note, and the specifics of it is outlined by the special warranty deed, saying that they didn't have previous title. So they
You can even be respondent though too.
Right, and what it's saying is they actually created a title. So it's not it's a broken chain of title because they actually created a new title, and that's not the original title. Boom. Case dismissed.
Yeah. If you look in the SOP for all these title companies and stuff, their standard operating procedures, it tells you right in there that it's standard operating procedure for them to destroy the note or the title about 10 to 12 days after the close.
Yep. It's a false title. Who can hold title to the land? No one.
I know. Are you going to get into? You're going to go through how the debt can be tracked through the SEC or service to do such? I'm very interested in your course. That's part of the Bloomberg, right?
That's part of the Bloomberg and the securitization audit.
Yeah. Okay. So, and we actually, if you go to the workshop, because I've been doing this quiet title kind of pro se because I haven't felt comfortable enough with an attorney up until now. Now I've got some good people. But prior to this, I just kind of stumbled into the courtroom, got frustrated, saw people losing their homes begging for an extra 30 days, and it's depressing. And I've been able to, make significant headway in properties in New York and Florida. So it really, and when I went to the workshop, even with that background, the wealth of knowledge I got is really.
And when we're talking about those securitizations, that goes to that indemnification and the private placement rather than the IPO, the initial public offering. That's what they're doing. When they securitize these things, they're pooling them in an investment fund so they can use them for initial public offerings.
Pooled stocks or pooled, general funds, they're traded as penny stocks on the public side. But because you have to read financials from right to left, that means if you read it from the private side, that tenth of a penny stock is at $1,000 each.
Yeah, it's called the mill rate.
Pretty much everything they do is a public option, isn't it?
Yeah.
Pretty much. Well, it's a lottery.
Yeah, well, it's a put on.
Right?
Yeah, it's like a hedge. It's almost like a morph of a hedge fund put option call.
Yeah, exactly. If you look in Northern Trust, you can actually find all those passports too. Sorry, go ahead.
Guys are taking this course. And for the question that just came in, you will actually see a detailed breakdown of the Bloomberg report, of the insurance payouts. All that stuff will be provided. So that's absolutely what you're going to learn for the securitization.
You will see Dr. Klaus shine. You will see him shine. He's an absolute whiz on this. See, Mike Forte is talking. His is research.
And now, Regis, can I offer another gift? Because
sure.
I don't know if it's only for attendees.
And the link to this video is down in the details below, folks, just so you know, as well as that PayPal link for anybody who wants to share some love. I always appreciate it. Thanks.
Your client
By the
title
way,
handbook.
Keith, really quick.
Yeah.
I found something this weekend when I was at the thrift store, go figure, and it was half off day, and it was in the books. I get lost in there. I actually found the, this is for Colorado, but it's Title Insurance Practice, third edition for continuing legal education in Colorado Incorporated, Colorado Bar Association, and Denver Bar Association. And I also, it's the teacher's like manual, like the binder, you know. And I also found
nice.
the Real Estate Practice, Volume 1 and 2, and it's actually the most recent one. I don't know why it was there, but there's some
Nice.
stuff in here we need to talk about.
Oh, cool. Yeah, we'll have to do
It's
that.
interesting.
Awesome.
Please.
Can I give that to the people who attended the call? Or is that just
Absolutely.
the attendees of the workshop?
No, if you haven't, if you've got it electronically, absolutely.
Yeah.
Absolutely.
So now Regis is going to give you, get out of credit prison. I'd like to give you on Regis's behalf a copy of the Quiet Title Handbook. So go ahead and email quiet-title. Anyone who's emailed us, the 2 investors that emailed us, we'll shoot it over to you guys. And anyone else, go ahead and shoot us an email, quiet-title@rosadocompanies.com, and we'll make sure we'll get that out to you as well.
It's good stuff. It's something you're not going to buy at Barnes & Noble.
Absolutely. I think that's it for questions, Regis. Do you have anything else before we close out? Oh, we have another question. All right. Everyone's waking up, and I'm going up and downstairs. Okay, here we go. I would like to know who in Miami, Florida does the securitization and how much is it, more or less? Now, I know we get into that in the workshop. Do you have a cost on the securitization service? I have an idea, but I don't want to misspeak.
All right. Here is the cost of the audits.
And this is another thing I want to remind people. This is something else I thought about, and I'm not sure on what to do with it yet, but remember, there's the state's blue sky securities laws, as well as the United States SEC. So there's a possibility of doing an indemnification through the state first, or through the state principally. Remember, the constitutions and the seating of jurisdictions, the original jurisdiction remains in the state. This is why if the states come up with a better assurance and enforcement of a constitutional element at the state level, it can be easily incorporated into the federal constitution. It's a quid pro quo
You can also,
contract setup. You know, it's an insurance on both sides. That's why they both have a United States Constitution, and each state has a constitution. Those are equal considerations.
well, it's the military side that's supposed to be the assurance part of that, that they blocked our access to a lot of that. But it's one reason why IRS is actually not Internal Revenue Service. That's different. IRS is set up as a kind of like an umbrella corporation that everybody can act through, under, by, whatever, because you can utilize that entity, you know, to leverage or do things like abatements or audits.
Right,
or
audit.
like determinations. Yep.
Audits are best.
So
Audits are the best because the audit will turn around and show that all those taxes you paid into the system are due back to you. They weren't justified.
You know what? I even found a very, very good one where if you can, if you know who you are and you can own up to the fact that we've made mistakes and and you can admit that, then you can literally fill out these forms there for all different kinds of taxes, like local government taxes, fringe benefits, all that. And you can, it's for public employers, because we employ the public, right, with taxes. And you can literally say that, you know, I haven't been keeping track, or have been doing a very good job, you know, employing the public. I need help. Can you help me audit this, please?
Yep. Absolutely. The IRS is your friend, folks.
Okay. I believe it's $1,260. That's combined. Now, I can pass this on. You could go online, because they sell software to do securitization audits, the same as they did sell software to do forensic audits. However, you can get a securitization.
You can do the same thing for anything almost. You get those purchases.
They have asked for it.
Yeah, you.
Sorry.
receipt that you get from your local grocery store is one of those signs that something's been securitized in the name of the United States, but it was securitized as a debit. So the claim there is that the indemnification should go to the United States, and you're the one granting it.
Because the receipt is the
Audit
credit,
done by,
which is the empty note, right?
Yep. It wasn't valid to begin with.
Joe and Janie up in Idaho, okay? What the audit must have is an affidavit with it, a sworn affidavit that becomes admissible evidence in court. Now, they're selling audits
I
on
have
the
to say
internet
something
from
right
any
there.
place from $800.
Say what?
Because this is really important. I have to say something here. This is really important about the whole affidavit thing. Because when you do an affidavit, affidavit is for an official, government or private. But you can actually see this if you look at the affidavit for Walker Todd or of Walker Todd. Every affidavit, because that's a title or an office, right? It's not living, has to be backed up or affirmed, by that one
Right.
occupying that office. The living
Right.
have to, affirm what the dead is saying, right?
Right.
So you need to have that affirmation backing up that affidavit, or you can just take the exemption on, because there's one I found in most states for just doing an affirmation, especially if you're like friends of the library and stuff like that. Quakers don't swear, and that takes care of everything. Is you can just affirm. It's an assurance. You're assuring. It's your word is your bond, right?
Right. And that's the grant. Grant means to assure, affirm. You're coming forth recognizing that you are the one granting the information, and that is true and correct. You affirm it to be absolute. Absolution.
The one thing that gets dicey with that granting thing, though, is the payment.
Absolution. Right. And that's the absolution, the redemption. I grant redemption. Look it up.
Oh, I like the granting redemption. Yeah, I like the I like that part. That's good. The only problem I see with the whole granting thing, and this is where it comes into trust, and I don't think people realize this, especially when it's like an irrevocable trust setup, is that once you grant everything into that trust, you no longer have any rights to it. You gifted it. You can't go take it back.
No, but in
it's one of
gifting
those
that,
things.
you gift it again when it comes to the title and stuff. You gift it the legal title. That is entry and control. While you have the 9/10 of the law, which is possession and use, and guess what? That title is in your possession.
Is
That's
that why they
your
do
trust.
that whole thing with gasoline, where it's like a dot, like whatever price and 9/10?
Yeah, that's a rounding figure so that they can use that as a base on that mill. Remember, folks, if you take
The
one
mill
penny,
levy.
if you take 1 penny in its decimal configuration, 0.01 times 0.01, you get 0.0001. Now, how does that equal 1 times 1 equals 1? If a penny times a penny equals a penny, but yet in the decimal system, it's 1/100th of a penny. Think about that. What are those bankers doing in the background with the decimal system?
To $2,000 per audit. We have worked out a deal with the company that we work with because of the volume.
And real quick, I also want to mention this, like I said, with the grocery store receipt, you can do an audit on those. You can do an audit on that purchase at the automobile dealership. You can do an audit on that major TV you bought from Walmart. Those are all securitized, and you received a receipt, which may serve the spoliated owner indemnification.
We have a large volume.
There's actually an app I found. It's called Safety Culture, because I was looking for auditing stuff, that everyone could use, because sometimes people get really overwhelmed by thinking about doing an audit. And the Safety Culture thing is actually really easy to use. They have like little tutorials and everything, but what I also found is they have a whole bunch of templates in there as well. And a lot of these companies have their templates in there. for auditing their own, stores and everything. The audits are already in there. Their audits for their own thing. They have a lot of stuff hidden in there. You should check it out.
Yeah. Oh yeah.
And it's free.
When we look at the history of the way corporations are supposed to keep records and stuff, not always when they have an issue with the tax and violation of laws are they put under. A lot of times, more often than not, they're allowed to continue doing business, but in their records, they have to maintain those records of those audits and stuff as a reminder that, hey, don't do that no more.
10Ks, right?
Yeah.
Yeah, right. Everything has to go on the record, and you have to record everything to the point of nauseum. But then it gets information overload, that kind of stuff. But it's funny because they also have to they have to train their employees and everything to be able to do these audits for them, especially the really big companies, because they are so big. So they have to make it easily accessible and not overly complex or anything like that. So when you find the apps that they're using, whether they're having their employees use for these things, it's funny because it dumbs it down. It makes it so simple, and you're like, oh wow.
Yeah. And
wow.
I wish
I was overcomplicating that a lot.
Yeah, and I wish more people would comprehend what auditing is about, because it's truly about keeping yourself correct. You have to audit yourself to make sure you're doing what's right. And that's the problem with society today. Nobody really gives a fuck anymore. And they're more willing to be a Hitler's willing executioner and use the excuse of
they don't want to do accountability, right?
Yeah, exactly.
Which means, they don't want to be accountable for anything, and they want to hold everybody else accountable. It doesn't work like that. You can't have your cake and eat too.
As we speak about accounting.
Just 12/6.
Yeah, right.
Now, once the audit has been obtained, now what do you do with it? Well, what Dr. Klaus does, and he charges $500 for his company, and they do a pre-litigation report. In other words, they will identify, not within the audit, but within the paperwork, the assignment.
The assignment. Oh, wait a minute. First point in audit, there was no assignment.
Well, in pre-litigation, right? That's mediation, right? Negotiations. And also he said just right there, I was cracking up because he's like, he charges $500 for his company. I'm like, oh, do you have to RSVP?
Oh, yeah.
Right?
He's probably backed up quite a bit, isn't he? I mean, but
well,
think about it.
A lot of this comes down to manners. It's insane.
Yeah, and think about it. They tell you in some of these videos the terms that you need to look for in specifically correcting those documents. And like I said, if they have contracts and they're talking about parties, well, what are the parties? Who's the real party in interest? Things like that. So these are the things that you use, that I use. Like I said, I've abated several things on the envelope and just sent it right back and never heard another word. I've abated things by writing nice little letters that explain that I see zero value here. And unless you can explain where that value is, since you use no dollar signs and never use the term dollar, all I see is an impossible mathematical equation. So I accept it for zero value. Thanks and have a good day. Never heard back from them.
We've been using greeting cards.
Oh, yeah? That's,
saying thank you. Yeah,
that's postcard style. Postcard. That's a security.
Well, it's not even a postcard because that one's private, right? It is a security, and most people don't realize it. And it's a security that most government workers and everything can accept. That's under OMB and all that. They can actually accept it. And it's funny because I've had quite a few people who have like a notice of foreclosure or notice of somebody bought that note, especially when the new lender comes back and says, we bought the note, blah blah blah. And now we have that. They literally write back oh, thank you so much for buying that. That was so nice of you. I really do appreciate it. That was very helpful. Thank you.
Yep. Absolves me of my debt.
No.
Yeah, absolves me of my debt. Thank you. I appreciate that. I really appreciate you redeeming me.
Yeah, a lot of it just literally comes down to thank you.
Fraud, if there is fraud, and there's fraud in 95% of the deals, okay? They will identify robo-signers. They will identify notaries that have been expired. They will
bogus assignee. I love those. Never assigned. Look at your certificate of title for your automobile. There's supposed to be an assignment. There's no assignment.
Identify so many things. And that litigation, pre-litigation report, we're under contract to a number of law firms, and they love it because for an attorney to have this pre-litigation report, he has to tell his paralegal, all right, start looking into this, get this, get that, get this, get that. And I can guarantee you it runs them more than 2 days of research. And he does that for a fee of $500. And so the total would be $1,760.
Okay.
No higher, no lower. That's it. We do not.
So for around $2,000, I think that's probably a pretty good value.
And you notice how he didn't say charge, or he said fee, and he said for his company.
Yeah.
Well, he might have said charge for his
me.
company. I don't think he says charge.
Yeah.
No, I know.
Have
It's just
affiliates.
funny.
We don't.
The wording, right?
Yeah, and that's why I urge everybody to pay attention. The language is specific. They use different grammar in different venues. So when we're talking about these fraudulent mortgages and stuff, understand they're also talking about insurance and credit and default and swap. That all sounds like subrogation.
And you need to look
everything's
at the
upside down and backwards.
definition.
Yeah, you
Yeah,
need to look
right.
at
You
their
need to look at the
definition.
definition for things in every, like multiple definitions, not just the legal. But like, I have Barron's
Right.
Financial Dictionary, which is one of my favorites. But I have like a plain language dictionary. I have it like every dictionary you can possibly find. But one of my favorite books that I have got so far, I actually found at an antique store for $2, and it was Standard American Business Practices from 1913.
Nice.
It is insane how incredibly exactly the same everything is. It's they're just updating the system. That's all. That's all it is. That's what crypto is, by the way. It's just an update, same system.
Yeah,
But just reading that, it gives
it makes things happen more instantaneously. That's what's so wonderful about this internet and electronic communications and everything. We get things so much more readily and faster.
Payout commissions.
But
not multi-level marketing. It's
still very important. So it's handwriting.
Absolutely. And Dr. Klaus's research has done wonders for me personally in terms of finding robo-signers and just finding fraudulent assignments. Anything. I mean, it's unbelievable what he's able to find with his team. So just so everyone's clear again, we've got 500 for the research.
TILA request. You see that? That was a TILA request. Truth in Lending Act. This is the informed use of credit. And you're charging me monies and other negotiable instruments and requiring me to sign. Why can't we just have the electronic transfer of credit appropriated as it's supposed to? I mean, I do have
question.
Go ahead.
Sir, I just thought of something. The assigned thing, right? Does that mean that it was never assigned, right? No sign. They didn't sign it? Is that why some people are finding
the only
remedy with the resigning of agents because it's re-signing?
Right. The only thing that was assigned was a social security number to an individual, which is a legal fiction, a presumption of the facts presented to the court until properly rebutted. The proper rebuttal is, I'm sorry, but that record was entered in error. Man was discharged of his mother's waters, and you made a record of a man, charging him the rest when he was already discharged. This is the importance of.
But I'm wondering because we never signed the contract, right? Technically, especially when it comes to the birth certificate and all that. Is that why we need to re-sign?
Right.
Because we didn't sign it.
Well, it's the salvation, the salvage. You need to salvage the assignment that was made in error.
Mm-hmm.
Whoever thinks they may have been appropriately assigned, I assure you, you weren't. I have evidence. Well, what do you mean?
Your record, appropriations.
Yeah, your records are not appropriate.
Searching again, I could
and they have all of the appropriated funds, right?
Yeah, they see, like it was said earlier, they're actually investing for you, and they get their investment back on that return, but the return is put in the account as a credit. So they're building credits for you. You're just not claiming those credits.
And then the 1,200. Now, I think what everyone needs to understand is that includes the full securitization, the Bloomberg, the affidavit, basically everything ready to actually bring it to the court. Or
everything. They can bring it to the court themselves, pro se, or they can take it to an attorney that we have already worked out. Any attorney comes to our workshop, agrees after they've attended the workshop. They can either say yay or nay, but they agree to a flat fee and a percentage on a contingency basis.
And think about what I said earlier too, the credit score versus debt score. How come there's no debt score? And while we're thinking about that credit score, let's remember that's like a black and red meter. Where
Well,
in the
and
debt
yeah, it's
score,
funny.
where hold on,
Mhm.
where in the debt score? Let me get a drink real quick.
Go ahead.
Where in the debt score would be the black. Excuse me, the is it the black that's negative? Yeah. And either way it is. You got one that's positive, one that's negative, and that's how you tell where you're at and things. So if you've got a credit score,
Red
it's
light, green
telling
light.
you right. So if you've got a credit score and it's only 500 and some, it tells you you've got a low credit score. So if you improve your credit, it's actually building credit. So isn't that telling you that you're putting more credit into the system somewhere? Same thing with the debt score.
Mhm.
If you knew a debt score, wouldn't you know
Mhm.
that you're putting more debt into the system?
And whoever holds the debt is the one that actually holds, that value, right? They issued it,
Yep.
that part.
At the end
But in
of
that
the
red
day.
light, green light,
So
that's
it's
in the FCC. Your red
You'll
light,
have
green
to
light.
point,
So
yeah, you'll have to point that out to me.
wonderful deal for people, and
I can show you.
we do our best to associate them with attorneys that understand what this is all about, versus an attorney that's going to take their money. And there are some out there going to take their money, but don't know what they're doing. They apologize and say, "I need more money."
Exactly. Well, I think that's hopefully clearing up any questions. Do we have any other questions that have come in?
And another point I want to make out is, when we're doing those, when they're doing that audit thing, they're the professionals and they like to do them a certain way. But like this guy pointed out, the one guy doesn't go into the audit itself. He goes into the documentation and audits the documentation for its terms and conditions. Again, remember, it's about tearing down a contract, not the trust, the
My
contract.
specialty. Yep. And that's the thing with
Good point.
when you're looking at it, nobody can tell you how to do like what to believe in, right? Or how to run your business or how to do your taxes. You can make your own audit process.
Absolutely.
They can't tell you no.
Nope. You get to let you get to learn how to self-govern yourself, self-govern in everything you do, and
Right, of
this government,
self-determination, right?
right, and that goes to your talents. And this government can't tell a potter how to make his pots. Period. He is the creator. He is the creator of what he is doing. He is the one manifesting the things that he makes. And that is Article 1, Section 8, Clause 8, and of course the Treaty of Berne, coinciding and correlating that you get to do that. And that's the parable of the talents. We're supposed to go forth with our talents. How is it that if we're supposed to go forth with our talents, you limit that ability by saying, no, you have to have a license to do that?
Well, and
So you get to really.
Go ahead.
So in all reality, you could really just shut them down by asking for the original acceptance of the public offering, directing the transfer of credits, and that would shut them down, wouldn't it?
Well, in the audit, the audit itself, and that's all you need to worry about. You don't have to worry about specific language yourself. If you're going to have somebody doing an audit, they're going to go in and they're going to find all of those details.
Mm-hmm.
They're going to find the original issue and find out what the rate was discounted. That's the OID. They're going to find all of it.
Well, that basically
You have to
is your
bring
chain of
the
title.
information forward. Yeah, but you have to bring the information forward. You can't just be asking them to bring whatever information they have forward or they don't have or whatever forward because when they don't have it, they can ignore you.
Well, yeah, you what you do is you point them out to inconsistent terms and conditions, such as when they say parties.
Yeah.
How is it that I'm defined as a party when that's the legal name that belongs to me? Things like that. This is why we have to come to a comprehension of what that language is, so we can help these auditors look for the stuff that we're finding. In my particular situation, I have them do an audit on this financial index. I can point out the specifics on it first and foremost, and that is the very different discrepancies, such as the last name and firm name. I've never been educated to use a firm name. Never knew that's what was happening. Never once been instructed to use the social security number without dashes. And now that I find out they use that without dashes and named it the obligor, and it's the obligor that is responsible for the debt or the obligation, right? So if the obligor is identified by a number, I am certainly not the number, nor is the name, nor is it the last name. It would be the firm name. So there are all kinds of things that were
Oh, the
converted.
obligor, though. The obligor is also the one that is the, holds the debt. They're the one that creates that,
Right.
they
And
funded it. It's like a sponsor, right?
right. And that's the one that's created by the state. So they created a false instrument. And this is why I say with the indemnification, we go to Revelation. We go to Revelations 18:6, where we're supposed to double unto her. Where we're supposed to double unto her under Revelations 18:6. So when they come with a bond for say $350, I'm okay. Well, I know you're doubling up, or you're doing 10 times or possibly 30 times. So let's go to the greatest possibility and say that you're doing 30
I
times.
found 144 on the first round alone.
Yeah. So it's a matter of letting them know that you're the creditor and you're going to put more credit on the table than they are, so they're going to have to fold. It's a big gamble.
I think we're good. So we do, okay, good.
Okay.
Another question.
Good.
This question is coming in and saying, this is, what, Regis, I was going to ask you this, and this is a great question. He's saying 1760. What's the end game? Property is awarded free and clear, question mark. What is the success rate? I'll jump in quickly and say that I've walked into houses that have been taken free and clear by two of your clients, and your friend there, Bernie, in Cape Coral, and I've actually stood in one of his homes, and the homes are adjacent to each other. So I've seen the product, and I've had my own dismissal. But we just explain a little bit what the end game is. I mean, we all want to see the properties free and clear, but realistically, what are the percentages?
All right, Randy, here's the end game. To get a house free and clear, I'm going to say that's a pipe dream, but it happens, okay? The ability to walk into the bank and say to the president of the bank, you have dirty diapers. Do you want to litigate, or do you want to negotiate? And they always would rather negotiate. And then it's a question of how much money they will take based on.
And that's what I plan on doing in the situation with my companion, if it ends up working out that way. Because see, the bank is the bank CEO is the trustee, and he's the one that's dirty. He's the one that allowed them to take money out of her account, knowing that they didn't have proper access. Or
I have a better option for you.
Or it proves his negligence or incompetence. Go ahead.
Well, I'm saying if we privately, I have a better option for you as far as not only proving that, but claiming everything back and then some.
All right. Got my email. Right.
I think I emailed you the other day.
Okay. I'll check it. Like I said, things have been up in the air here, so I'm getting behind, but.
No, I get it. Yeah.
All right.
Today's value. So if a home had a mortgage of $400,000, it's worth $200,000 today. Banks are negotiating between 30 and 60% of today's value. Now, can the individual homeowner negotiate? No, because then the bank says, well, why don't you pay me in the first place? But through a program we worked out, we have investors that will buy that note, take a fair profit, keep the people in the house, and give them an opportunity to refinance under FHA guidelines under 4155 2 years later. And everybody wins. And the homeowner has his house at less than today's value.
And again, that refinance, remember, if you understand what's going on here, you can always present the documentation under that refinance so that it's done as a credit device, so that you obtain that home on credit. And like I said, that credit's already there. Just like the bank went in with that $400,000 note, and they gave them $4 million credit. You're going to give them a promissory note, and you're going to get credit back. In that, your cup welleth over. Now you can start sharing with the community. That's the premise.
That's already there, though.
Right. It's
That's
called
what
settlement.
I found. Yeah.
It's called settlement. The land is already settled. That part is already settled.
Mhm.
Start living.
Yep. Well,
Well,
it's just
okay,
that credit from
why
the
would
bonds
someone,
that they've issued that needs to be
Right.
claimed. That it's tax exempt because it's literally people. It's them issuing life insurance policies on us, and it's that's why we have to swap out the collateral. You know,
Yes.
for that something else
Yes,
with the thing.
and tell them what what collateral is.
Right.
Can you tell them what a collateral is?
Oh, okay. I didn't know. So collateral for a for a debt. So you'd have to have normally a tangible asset, something you can touch, right? To back up an intangible asset, that note or title or a description of that property. So that collateral is what backs that up. And you need both of those in order to have what's called real property, not real estate, but real property. The problem and where we get hemmed up a lot is that most people don't know how these accounts are funded to begin with, and they're funded by life insurance policies on us, which are also called mortgages, mortgage, death pledge, and which sadly makes us the collateral for that policy. The reason why they use these policies to fund it is it's because it's one of the what's called it's one of the very, very few financial vehicles, right? Vehicles, mobile home, that is completely and utterly tax exempt. Even the interest and income is. And because of how they reinvest in itself, basically all the interest and income that is generated by those policies automatically reinvest into more policies. And it just keeps going and going and going. You couple that with the fact that nobody can ever predict how productive somebody's going to be in their life. That's why these
Right.
Accounts are considered, bottomless or endless.
Right.
But because it's, our butt that's the collateral, you need to swap
Right.
out the collateral or that tangible asset that's backing that note.
And that's the same with that private life insurance policy. The same thing happens if people don't understand how that system works. And the guy passes away, everybody gets benefit of their life insurance policy as a part of a revocable trust that is now irrevocable.
Because a revocable trust, which is basically an LLC, it automatically transfers into an estate or an endowment when somebody passes, which is an irrevocable.
Yep.
And sadly, those are the only two forms of equitable trust, though.
Yeah, and that's why it's important to maintain that living will, so that when the testator passes away, you can administrate that trust or execute the trust with a competent successor that will do so to the benefit of the beneficiaries without a third-party intervener, interloper, period. It's not
Exactly,
public
and you need to have that administrator and executor position filled because that's a legal and fiducial title. There's always that balance, right? And that's one thing that the lawyers have us not do is appoint an administrator, which allows probate to come in and be like, oh, well, I can do that for you. And then they just rob and raid the account. And I called IRS and I asked, because there's something that we're supposed to do. I found in a letter from 1947 from Treasury. It's with our loved ones, with their estates, their endowments. We're supposed to do what's called bind the book. It's closing accounts, balancing everything out. Right?
Yeah.
It's funny, huh?
A man is bound by his word. A man is bound by his word.
I know, right? Yeah. Yep. I bind all my successors and heirs, right? Well, we're supposed to bind their book for them. And I found out that it takes roughly about 2 to 4 years for this to happen because of the amount of information that they have. And it does cost money, but the thing is you can have it, have them charge the estate, right? I actually called and I asked the estate department if they had ever, bound any books. talked to someone who worked there for 21 years. She said she never has. What does that tell you?
Wow.
Tells
Yeah.
me that
See,
the
that
courts
tells
aren't
me
doing shit that they're supposed to be doing,
Yep. So, yeah, it's
which is scary.
yeah, very scary, and that's why I say, it's up to the people to become knowledgeable of this, so we can keep track of these people that aren't doing their job by knowing they're not doing. I know they're not doing their job, but what part of their job are they not doing? Can you say specifically? I can.
Mm-hmm.
Been doing it for a long time, and that takes a
Not
matter
many
of.
people can.
It's kind of like being a jack of all trades, but a master of none. You got to know enough about them and what they're doing to learn not to give up the comfort and convenience of letting them do it for you. You know.
Exactly, but they
To
have
make money,
everybody thinking that you need to be a
but they don't
master of
own it.
one thing, right? Which
Yep,
that's
that's your
departmental is.
profession. That's your profession, right? My profession
Yeah,
is truth. My profession
yeah.
is truth. Truth, truth, truth.
And then issue
Knowledge.
a 1099 for debt that they don't have coming. That's a Ponzi scheme.
That's what you were talking about earlier. And then issue a 1099 for a debt they don't
That
have
B.
coming. Yep.
Yeah, that 1099B that
The banks
everybody's
and Cruz.
doing, they're supposedly creating a book value.
Yep.
It's very dangerous, and that's going to come back because the IRS does not get those records for 3 more years, and then they have 7 more years to act on it. So that can come back and bite people in the ass 10 years later.
Yep. Better know how to put that value to it, guys.
Through a quiet title election that they are the real holder in due course, then you can negotiate with them. But these people are stealing. I'm done.
Yep. Real holder in due course, real party in interest, basically about the same thing. As holder in due course, you have right to enforce the instrument. And that's all we're talking about. You have to enforce
And I have a question for you.
You have the right to enforce the instrument under that quiet title because it's got a special warranty deed. That's saying that title isn't good. Go ahead. Go ahead.
As far as enforcement goes, because this is something I keep going around and asking everybody, because I, because of my situation with my trust and everything, was never able to actually get any enforcement in the courts because of my trust. Long story, but I've had to look for other avenues. But everybody I talk to, whenever you ask them about enforcement, everybody said go to court, take them to court, sue them in court. I mean, do you think that there's other avenues to
Yeah.
hold them accountable, or to
Well, yeah, in equity, you get to create a remedy. Part of that remedy can be continuing education or discipline by the necessary supervisors, or both.
And it's funny. I was actually going to send a greeting card to one of the under sheriffs here about a couple of his deputies, about how they need, some more education
Yeah, many of
for
them
their
do.
reprimands, right? Yes, they do. And well, I mean, it's a lot of money and time that's invested in that, so you might as well not waste it, right? Fraud, waste, and abuse. And you might as well put it to good use. And I know that they're going to hate their life by the time they're done with all of the courses I'm suggesting. So,
Yeah.
different option. But it's those people, when they talk about equity, they think that all I hear is, take him to court and then you can enforce it, equitably in court. And I don't see the courts
Yeah, you
really
can't
being
do it.
equitable in my.
Yeah, you can't do it in court. Equity imputes an intent to fulfill an obligation, and that means a contract. So you have to do it by a private contract. That's not a court action.
See, and that's what I think. Exactly. I have found one thing though in the IRS that is probably the closest to a chancery or equity that I've found. It's a private letter ruling.
Yeah,
You ever heard of that?
it's like a private relief law. Same thing.
Yeah,
Look
it's
up.
you send them tell them a letter and give them, this is what I'm trying to do, and they'll write you back and, well, this is what we can do, this is what we can't, and you just go back and forth until you reach a meeting in minds.
Yep. And what
And I don't
was
ever
it?
see the courts do that or shit.
And what'd you call it?
It's a private letter ruling,
Private.
and they're not
letter.
allowed to base ruling. Yep, and they're not allowed to base any private letter ruling on any previous ruling at all. They're only allowed
Right.
to base it, the decision on what they're allowed to do, according to not even the statutes or codes, but according to the instructions and publications from the IRS. That's what they have to base it on. Just
A
what they're able
private
to do.
A private letter ruling is a written decision by the Internal
Mhm.
Revenue Service that is sent in response to a taxpayer's request for guidance on unusual circumstances or complex questions about their specific tax situation. For certain transactions involving large amounts of money, the tax law may be unclear. Interesting.
Yeah, because it's not so much you want to be using special. Because one thing I did find that the courts are doing is they're they're using special as also, special. Like my grandmother would say, touched, short bus kind of thing. Not good. So you're now incompetent. And yeah, I know they're funny, aren't they? They're just adorable. But specific, on the other hand, specific is very specific. It can't really be construed and presumed in anything else for what you are specifically stating, right?
Yep. Anybody need a ride on that short bus? Let's go.
Well, that's how Trump's accessing all his stuff through the Able account. But
Yeah.
it's also the reason why he's in hot water right now. He made himself incompetent and he pissed off his wife. So there you go. Now he's here.
Uh-oh.
Uh-huh.
Let's finish this up real quick. We just got a couple minutes, so let's finish this up. And
The other question that came in, I'm not sure if this one you know anything about. I don't see why it would be any kind of difference, but we've got an investor in Miami who wants to know if a judge will honor a securitization in Miami court, even if there was, I guess, a retirement to act in foreclosure or retirement act in foreclosure cases that they may not know about.
Well, here's the answer to that. Here's the answer to that. When you are in foreclosure and your attorney is representing you or you're representing yourself, you are in what we call a court of equity, or the judge is ruling on tort law. And that's the amount of the debt. Do you owe the debt? Do you not owe the debt? Is it fair? Blah, blah, blah. And your attorney is representing you or you're representing yourself. You are in what we call a court of equity, or the judge is ruling on tort law. And that's the amount of the debt. Do you owe the debt? Do you not owe the debt? Is it fair? Blah, blah, blah. A quiet title action is contract law. A court of equity, or the judge is ruling on tort law. And that's the amount of the debt. Do you owe the debt? Do you not owe the debt? Is it fair? Blah, blah, blah. A quiet title action is contract law.
contract law, folks. Understand that. Equity imputes in an obligation or an intent to fulfill an obligation. That's contract. Equity was merged with common law. Equity is trust law. Common law is contract law. So come to the fellow man in private with the contract. Matthew 18, verse 15. Go to your if you have aught with your brother, go to him in private first. If he denies you, then you go to the public forum. You go to that public forum offering that contract that he's not willing to take.
Contract law. It's not a question of money. The judge is not ruling against an attorney who just wrote him a check.
In that offer of that contract law, you're going to express why he won't take it. Because he's not acting in good faith. He's converting language. He's babbling this and that. He's negligent, incompetent, whatever. You have to learn how to explain this stuff by learning how you're supposed to behave in these situations. Yes. Misfeasance and malfeasance. Misfeasance is not knowing. Malfeasance is after the fact. You knew and did it anyway.
Night before.
Well, and you have also like embezzlement and larceny. Two other good terms.
Yep. Robbery in basic includes larceny, embezzlement.
Yeah.
It's contract law.
I would stay away from fraud.
And the security.
Yeah, it's fraudulent because you can prove that it's not correct. But again, it would only be fraud, again, if malfeasance is availed where somebody obviously did it with ill intent. That's the problem with all these people saying, I'm just doing my job. It proves that they don't have any intent. They just don't know what they're doing. Forgive them.
securitization report with admissible evidence when presented properly. When presented properly, and the pleading is presented properly, the right attorney understands it, and it lets the judge know that his decision will automatically be appealed. He doesn't want to go to appeals court, so he will make a ruling on contract law.
He will make a ruling on contract law. He doesn't want to go to appeal because appeal deals with what? Equity and trust. If he can solve it with contract, which is why the contract statutes, codes, rules, and regulations are equitable, you can insert yourself with your own contract terms and conditions as that third-party benefactor, letting them know that if they ever want to hire you, it will cost them this much.
That's called contract law, is that arbitration.
Yep, arbitration. You got to have your fee schedule, all that kind of stuff. Let them know, hey, if you don't want to fingerprint me, yeah, if you want to contract me with that license and say I have to give you ID, and if I don't, you take me to jail on that purpose, looking for that ID, and you want to ID me and take my fingerprints, $250,000, or maybe it's $2.5 million. I can't remember. You'd have to look at the fee schedule. It's down there.
I hope that answers that question.
25,000 per.
So, let me pop out and come right back, folks. My video stopped again. I noticed that a while ago, but I wasn't going to do it then. Be right back. Okay, we are back. Let me see what I got here. There we go. So what do you guys think? You there? Am I here?
I think people need to start putting together their own contracts for, figure out how they're going to be operating and how they want other people to be operating with them.
Yeah, and that's one of the first basics about communication is letting people know how you want to interact and what the interchanges are going to involve.
Mm-hmm.
And we
but it tends to be a little bit harder of a thing to do though too, because most people don't know how they do operate or how they're going to or want to or yeah.
Well, one of my favorite stories was Tom Sawyer. I love Tom Sawyer. Samuel Clemens, Mark Twain, Tom Sawyer. I'm a Tom Sawyer guy myself. But one of the reasons that Tom Sawyer is one of my favorites, when you read Tom Sawyer, the story about the fence and him painting that fence for his aunt. So that's the part about being in servitude to somebody. But that somebody that you're in servitude to isn't a heathen. He isn't an overlord, master, slave driver, but rather somebody impeccably admirable. Somebody that has great respect throughout the community. My aunt. You know my aunt? Oh, yeah. And all the people that came passing by watching and asking about painting that picket fence, he would explain this great honor. And he was willing to pass on that honor to them if they had something valuable to give him. What a way to contract. Kids coming along, hey, yeah, I got a slingshot. I got this dandy slingshot. Okay. Yeah, I'll give you, you can paint these 5 boards. He's got kids coming along watching, and he's sitting there telling the next kid, he's got them lining up, listening to this story about how it's so honorable to paint this fence for his aunt. So did Tom Sawyer really paint the fence? He got the job done, didn't he?
Mm-hmm. That's the whole service provider, right? It's like all these matchmaking companies and everything, but it's well, if you don't select your service, right? Yep. Somebody's going to select it for you.
Yeah, absolutely. So, and that's why I say, there are certain things in life that tell me that there is definitely something wrong with the hearts and minds of men in these modern times, where it seems to me we're becoming more and more like Hitler's willing executioners. And that's because we don't understand how we're communicating with each other and how that is actually how we're contracting with each other. We take things so literal in this speech that we've learned that we forget about people's actions and fail to see them. This is why we have women that are abused or men that are abused, and they keep going back to that same relationship. It's pathetic. Same thing with the government.
Is it so much that they're taking it literal? Because it's one thing I found with is that I'm very literal, and one thing I get people tell me that when I'm being very literal that I'm being cryptic or talking in circles. And so I have to then use some kind of metaphor or analogy in order to explain what I'm trying to convey, right?
Yeah.
And then they get it.
Yeah, and I get the same thing. They say I'm always twisting the words. No, I'm trying to show you where they come from and how they twisted them into what
Exactly.
you think you know.
It's because you have to look at it from all perspectives, right?
Yeah.
I think people's
Yeah,
so
that's
fast
the
paced
problem.
today, trying to provide with their careers and everything, that they really ain't got time to stop and look and take, any time to give it any thought.
Yeah. Yeah,
Well, and I think
and
that's the one thing that COVID did is give people opportunity to stop and look, and I think it sparked enough curiosity. I think it backfired much more than they realized.
yeah, and
Yeah, that put a serious hurting on a guy like me. They shut us down. We couldn't even work for like 9 months.
yeah, it put a lot of people
Literally
down.
destroyed me, killed me.
Yeah. Imperium Private says quiet title is a C.O.W.A.R.D.S, and C.O.W.A.R.D.S is error in the record, and that goes with a quo warranto. I'm not questioning your title or your office. I'm questioning the record. It's an error. That's the
Errors and
absolution.
omissions.
Yep. That's the absolution.
Yep.
I
Yep.
absolutely guarantee you that it is an error because I'm the one that put those data elements in there. I'm the big dummy. I apologize. I'm sorry. I won't do it again.
Absolutely.
So
Well, you
anyway,
can call them when you do call them on theirs. It's also it's a counterclaim on their
yeah,
insurance because what they're doing with you is basically making a claim on your insurance saying that you've harmed something or someone. Typically, you're actually suing yourself in court.
yep. And I'm gonna check it out tomorrow. I'm gonna call down and find out if those officers ever did put in a trespass on me, and if they did, that tells me that they converted the information that I gave them to a legal name and a birth date, and that's a no-no. That's a no-no. You're
Oh,
you're
they've even lately they've changed my birth date that they've been using just
oh
recently,
yeah,
which I found very interesting because that's a pin. Yeah, that birthday is a pin number for EFTPS. That's how they access it. I'm all like, so you guys don't, you guys didn't even just change like the styling of the name. You created a whole new person. Wow.
yeah. That's what I tell people that every time you get a new citation, every time you sign your name, what you're doing on any document, you're creating a new person. The individual's name and number identify the record. So every time you create a record, you use that name, but they've got a different number on that record. You're creating a new person.
Yeah, but the thing with the birthday, the reason why the birthday they need it so badly, right? Is because in the license, is because it's the PIN number for the EFTPS system for like basically your social account that they have that they tap into. So for them
Well,
to actually change that, yeah.
Yeah.
that means there's a lot of kids out there without fathers,
Yep. Yep.
even within the record.
Well, Paris Patrick.
Yep. Local parentis. Anyway, we come to the end of the stream.
So
What do you guys got on the way out?
thank you.
Well, I appreciate both of you guys' time tonight, and you shared with me, and welcoming you up to your platform, and like to encourage everybody to take a little time. I mean, some of this stuff is in plain language. I
Yep.
mean, I think I think that spiritual foundation is so important because I think it would open up the mindset of people and it a lot broader when it comes to these things. I think it really is a detriment to somebody that doesn't come into it with a spiritual foundation because they never really see the true value in it, any of it. Just my take. But
Yep, and
much love and to everybody and many blessings.
absolutely. Thanks, Russ.
Thank
Absolutely.
And absolutely, if you don't know the language, how can you see the true value in things? If you're confused by the language and the value that it purports, how do you know the true value? This is why it's important to get to know thyself. There's a communication between yourself and a higher power that is always going to be more truthful with you. Intuition and instincts. What do you got, sister?
Definitely. Thank you. It's a pleasure as always. But go back to your guys' documents, contracts, anything else that you have, like already have, and read it out loud. It's amazing what reading out loud does. But read it, like read it a couple times. It's amazing. You're gonna be like going through there and like, oh my gosh, did they really? And yeah,
Yeah.
we have most of the information. It's not so
Yeah,
much
it's
them
like,
hiding it. It's just we didn't take the time to read
yeah,
it.
yeah, and like I said, look at your certificate of title for that automobile, that motor vehicle, whatever you want to call it. Look at the certificate of title. There's supposed to be
Oh,
assignment
I'm
on
so
there.
pissed.
It's missing. It's not there. Who assigned it to you? No one. They just signed it over.
Yeah.
The old owner signed it over, and then you took it down to the registrar or the treasurer, gave it to them. They gave you a new title with no assignment. No assignment. So think about that.
And but read the contract too from like if you get it from the dealership and stuff too. I remember doing that for the first time. I was so mad afterwards. I was like, and it felt so stupid, but
Yep.
but it was very educating or edifying. But
Yep. All right. With that, folks, we are out. And you know me. I love you, but I don't give a rat's ass whether you love me back. That's to say, I don't care if you hate me. I don't care if you don't respect me. That's on you. So may God bless you and have a good night. We'll see you later.